Welcome to Evidence Law, week 10, the final week of new material. We'll have some recitation material next week, but this is the final week of new material, and we're going to go deep into the topic of proof. So to recap where we're at, which might be useful, especially now, we've talked about the largely procedural rules about adducing evidence in the form of a document, transcript, recording, witness, and we've talked about the admissibility rules that apply once we have properly adduced the evidence. The most fundamental one being determining if the evidence is relevant and for what purpose. But then we have several, and then we know that prima facie, any evidence that is relevant is admissible, but then there are several admissibility or exclusionary rules that might exclude that evidence despite it being relevant to some fact and issue. Rules like the rule against opinion evidence, the rule against credibility evidence, the rule against hearsay, on and on the list goes. Once we got through that, we talked about the sort of final hope for somebody who wants to exclude evidence, the light of Aaron deal, which are these judicial discretions, or sometimes mandatory in the case of Section 137, to exclude evidence, typically based on some sort of balancing exercise. And now we're on to proof. So when I talk about proof, I generally mean the determination of, based on the admissible evidence, has the party that bears the burden of proof, typically the plaintiff or prosecution, have they proved their case on the applicable standard? So we talked a bit about that already. This is proof part 2, the deuce, just like the Death Star part 2, which is pictured there. Hopefully, proof part 2, the deuce, will have a better outcome than Death Star 2. And there won't be so much hubris involved. We can hope. A new hope. Anyhow, we talked a bit about proof, or David Hamer in an excellent lecture towards the beginning talked a bit about proof. And we talked about concepts like the burden of proof, which in a criminal case is the burden of proof beyond a reasonable doubt. And Section 141 of the Evidence Act. We talked about the civil standard, which is proof on the balance of probabilities. Again, and that might shift depending on the severity of the claim, the common law rule being there from Briginshaw. And we talked about the cases like Green and Duquea about to what degree should the trial judge be explaining to the jury what beyond a reasonable doubt means, and how much influence, how circumspect, how cautious should the trial judge be in doing that. And I think the reason that we talked about proof at the beginning was to give you a general idea of where you're going, why we're bothering to admit this evidence. But now there are some beyond that, general thresholds, beyond that general burden of proof and to what extent, there are more discrete issues of proof that we should talk about. They're generally within Chapter 4 of the Evidence Act. And we'll talk about several provisions within Chapter 4. And in fact, we'll find that there are many ways in which a judge can exert further influence over the proof process. So we talked a bit about, throughout the exclusionary rules, to what extent is the judge being proactive? And as we've seen, the High Court has sort of reined in judges from being too proactive in excluding evidence, generally trusting that the jury can come to the correct decision without withholding evidence from them. But here's a final way in which a judge can exert some control by providing some sort of warning to the jury about the evidence, explaining how they should use the evidence. And in the case of judicial notice, a judge can take notice of, can, in their own fact-finding or law-finding process, look at evidence that was not brought by the parties. So maybe a further incursion into the adversarial system and away from the notion of judge as umpire. So here are the provisions that we're going to look at today. As I mentioned, most of them can be found in Chapter 4, except for the first part, which is actually in Chapter 2 when it comes to adducing evidence. Even though it is in that section, that chapter, it's about the instruction or comment that the judge will give a jury in particular cases. So we're lumping it into the proof section, even though it's not in that chapter of the Evidence Act. Then, as noted, we'll go into Chapter 4, which started with judicial notice. And from there, various warnings and other rules that concern evidence that may be misused by the jury. We'll end up with sort of a few reflections, a few more normative perspectives on the proof process, some perspectives from outside of law per se. So let's start off with what I've lumped under this heading of the right to silence. Although it's not technically a correct term, because I don't think there actually is a right to silence. The primary section that we'll be looking at here is Section 20 of the New South Wales Evidence Act, and it's the judicial comment, or I should say, any comment, although we'll look at it in the case of judges, on the accused's failure to give evidence. We see in subsection 1 right away, this is limited to criminal proceedings. And subsection 2 says that anyone other than the prosecutor can comment on the accused's failure to give evidence, but must not suggest that the failure was because the accused believed they were guilty. Sections 3 and 4 sort of extend that to spouses, partners, parents, children of the accused. And subsection 5 has to do with allowing judges to comment on the co-accused's comment itself. Note that this section does not exist in the Victorian Evidence Act. Instead, there are slightly different rules in their Jury Direction Act. So what we're going to see is that at common law, there from this case Weisensteiner has always been, or since Weisensteiner, there's been the ability, or the judges have been allowed to make certain comments about the fact that the accused didn't give evidence. This seems to, in some ways, encroach into the presumption of innocence, because we typically think that the accused does not have to give any evidence. The accused doesn't have to explain their actions or inactions because they're presumed innocent, and it's in the accusatorial mode, it's the prosecution's job to prove their case beyond a reasonable doubt. However, common law, there is slight encroachment into that, and it seems to have been winnowed back over the years, and Section 20 as we'll see, might further limit that in the wording it uses, especially the word suggest. Comment must not suggest that the defendant failed to give evidence because the defendant was or believed that he or she was guilty of the offense concerned, which is 20 sub 2. So let's, we're going to, the two common law cases we're going to look at are Weisensteiner and as a party. And yeah, so what's at stake here should probably be the question. So we often talk about various reasons we have evidence rules. The first one we sometimes think about is factual accuracy. And here you might wonder, okay, how probative, how useful in the fact-finding process is the accused's failure to give evidence? And will instructing juries that they may take into account the fact that the accused didn't say anything when determining if they're guilty or not, will that actually improve the jury's fact-finding or not? It's also the principle of efficiency. These are all the ones that David very lucidly went over, I think, in the first lecture. Efficiency doesn't seem to be triggered here. What about fairness? The rules that would notionally, the principles, I should say, that would notionally prevent a judge from commenting on the accused's failure to give evidence, probably based on fairness, right? There's a golden thread in criminal law, in criminal justice. There's the presumption of innocence. There's the burden on the crown. And you would think that cutting that back would offend some of those principles. Finally, we often talk about the adversarial system. People who've written some of the essays, the optional essays, have thought a lot about this role of the judge as the umpire and not someone who's jumping into the fray. But here in cases like these, the judge does somewhat jump into the fray and provide this instruction. And there's a question of whether the judge should be restrained from doing that. So the foundational case in this area of law is somewhat of an unusual case, and that might matter because we can discuss if it should be constrained to its facts. But it's Weisensteiner. Lots has been written about Weisensteiner. Weisensteiner was this is a Queensland case. It was a man who was hired by Hartwig Barrel, great name, and Susan Zach. They go off sailing from Cairns, and eventually the boat is found with just Weisensteiner in it. And he doesn't offer an explanation of what happened. There's a lot of sort of there's in some of the things that have been written afterwards, there's lots of interesting facts that never really fully made it into the report. But Zach and Barrel were concerned with World War III, a nuclear holocaust. They put their life savings into making the boat battle-proof. Barrel also believed that he was interested in the Freemasons. He thought there were lizard people, aliens among us. And the general plan was that they would, with Weisensteiner's help, sail off to stay safe and wait out this Third World War and just come back when everything was safe. And Weisensteiner actually helped them put bulletproof steel on the boat. It's a very colorful story. I won't really get into that. And the trial judge, the prosecution requested an instruction that in a case like this, inference of guilt can be more safely drawn when the accused does not give evidence that's likely in their knowledge. And the question was it proper for the judge to jump in like this or not? The actual direction is here. I think the key line would be such an inference may be more safely drawn from the proven facts when an accused person elects not to give evidence of relevant facts, which it can easily be perceived must be within his knowledge. You might, for example, think in this case it requires no great perception that the accused would have direct knowledge of events, which can be canvassed only obliquely from the point of view of seeking to have you draw an inference from the evidence which has been led by the Crown. The use you can make of that fact that there is no evidence given or called by the evidence in the proceedings is that. So this was the accused argument, which one would think was a strong argument. The appellant argued that just as it's impermissible for a judge to suggest that inferences adverse to the accused may be drawn from the exercise of the right to silence, so it is impermissible for the judge to suggest inferences adverse to the accused, which are available to be drawn from the facts proved by the Crown, may be drawn more safely when the accused does not give evidence. The High Court disagreed. They thought that there is a distinction there. And the accused said, no, it's to say that you can more safely draw certain inferences is the same thing as you can draw adverse inferences. It is sort of hard to see the difference from my point of view. Then they give what I suppose is the ratio of this case, that the election to remain silent can't be taken as an implied admission, but when the failure of the accused to give evidence is a circumstance which may bear upon the probative value of the evidence which has been given, then it can be used to more safely draw that inference. And there's a kind of question of, is that an instruction that's conceptually clear enough for the jury to understand? There's a question of how unusual the case is this, because this is kind of unusual set of facts in which Weisensteiner was it's almost as if he was there, he must have known, it's very likely he knew what was happening. And so most of the determination of the facts in this case depends on what he saw. And we know he must have seen something. He was on that boat, it was close quarters. It'd be unlikely he didn't see anything. So it could be very, very narrowly. This case can be read to be quite confined to its facts or not. It turns out it wasn't. It's been relied on quite a few times. It still is. What actually happened? There was a book about this later on. It's not quite clear, but he lost. He went to prison, but when he got out, he provided some interview that was later translated back into English, which suggested that he claimed that the boat was sort of raided by pirates, and Susan Zach was killed, and eventually the other gentleman left him the boat. He went to go pursue some other adventure, and that's why it happened. Arguably just as inconceivable as him murdering the two of them. So it's hard to know how a jury was convinced beyond a reasonable doubt. It seems like that instruction didn't matter in this case. Years later, and as a party, in between Weisensteiner and as a party, there was a case RPS, which seemed to narrow Weisensteiner. And there was also, now that we're in New South Wales, we have Section 20 to consider. And how does that play with Weisensteiner? So this was a case in which the allegation was that the accused hired somebody to kill somebody else, and the accused did not give evidence. And what you got was, sort of a Weisensteiner instruction. So you can take into account silence because members of the jury, you may think that it is logic and common sense that where there are only two persons able to give evidence about a particular thing, and where the complainant's evidence or the witness's evidence is left undenied or uncontradicted by the accused, any doubt which may have been cast upon that witness's evidence may be more readily discounted, and that witness's evidence may be more readily accepted as true. So there are two sort of useful clarifications in this case. I have them highlighted here. So first is that this should be construed as a comment. So it should be clear that the jury is not required to follow this. It's just a comment from the judge. Nothing should be worded in a way such that they know they can take this into account, but they don't have to. However, as with all comments, it will often be safer for the judge to just kind of leave this be. So seems to be kind of consistent with cases like Dukia, where the less you say, the better. Also provides an interpretation of Section 20. The effect of the subsection is that the judge, the accused, and any co-accused may comment on the fact that the accused did not give evidence, but the judge may not, by that comment, suggest that the accused failed to give evidence because he or she was guilty. And suggest is a word of very wide application. So you have to be very careful that there is nothing in what you're saying which could very broadly suggest that the accused didn't give evidence because they thought that they were guilty or because they're guilty. So this would suggest that Weisensteiner should be sort of read very narrowly and not given out very often, because in many cases you could suggest that the accused had some sort of motive not to give evidence and that they were guilty. Also seems to narrow Weisensteiner, and it describes it as very unusual and in sharp contrast to the more common cases like a sexual assault where there's only two witnesses. It describes Weisensteiner as a case in which the facts are only really known by Weisensteiner, by the accused. Finally, note that the content of the comments, according to as a party here, should not be, the judge shouldn't sort of couch this in terms of the accused failure to give evidence because the accused does not have to give evidence. It should be more the accused lawyer failure to offer an explanation for something that they should be able to explain. All right, moving on to judicial notice. Can the judge bring in evidence into the court? And if so, in what circumstances? This you might see as a pretty extreme move away from the umpire view, where the judge is merely there enforcing the evidence rules as against each party and informing the jury of the relevant law. Here, the judge is actually bringing in the evidence. Is that appropriate? When is that appropriate? Well, there really is no issue when it comes to matters of law. Proof is not required about the provisions and coming into operation. the judge can inform themselves any way they like about that. And that's pretty clear. That's sort of the role of the judge as the arbiter of law. And it's within the judge's knowledge and competence. We expect judges to know the law. The parties will make submissions about that, of course, but the judge is free to do their own legal research. I'm sure many of you will have the opportunity to be a judge's associate, and that will be a big part of your job, to research the law for the judge. It's quite different with the facts. So 144 is something of an exception, saying that if it's a matter of common knowledge, so within the locality in which you're in, everybody knows a certain fact, then proof is not required. The judge can acquire this knowledge any way they see fit. Then the court can take that knowledge into account. There's a jury, the jury. However, the judge is to give parties opportunities to make submissions about these facts. Important to note here that it must be common knowledge. So typically these are things like, it's in this particular area, it rains a lot during the summer, it's hot during the summer, something that everybody knows. But what are the limits of that is the question we'll look at in a few cases. And before we do that, what are the policy considerations here? We talk a lot about this for every rule. I suppose one is factual accuracy. If it's not a matter of common knowledge, there's a concern that if the judge does some external research and brings in some sort of scientific article they find, tries to summarize it for the court, they might not get it right, because that's just not something judges are trained to do. It's also an issue, I think, of fairness. We saw that in 144 sub 4. There should be requirements if this is not brought through normal adversarial channels, that the parties will at least get a chance to scrutinize it and make submissions about it. But I think there's also some issues of access to justice via access to science. And by that, I mean, there are going to be cases in which the parties, possibly for economic reasons, maybe often for that reason, don't have access to an expert witness who can come in and explain something that is not common knowledge. So something like the effects of domestic violence, intimate partner violence, and these could be relevant. This could be relevant evidence for a defense of self-defense if it's a battered spouse who kills their partner. You want to know the context and how battered spouses behave. They might view the violence slightly differently. After habitual violence, they might be more prone to see aggressive behaviors when outsiders wouldn't see that. It would be useful to have this knowledge about how domestic violence works. So can a judge bring in evidence of that if the parties haven't hired their own expert, possibly because they can't? It's an important and I think interesting topic. Both David and I have written about this recently in these 2 articles, which you can look at on your own time if you're interested in it. But it would seem like the normal adversarial processes don't always bring in the best external knowledge. And at what point should the trial judge do that themselves? So we'll look at a couple of cases to illustrate some of these principles. First is the High Court case, Woods. Woods was injured, lost most of his vision, and sued the facility for not providing helmets or warning about potential eye injuries. And here the High Court, some of the High Court wanted to take into account statistics about the cost to Australian society for accidents. The idea here wasn't really about the facts about whether MSH was negligent, but the High Court, as it has in some cases, a policy setting function or a lawmaking function in some ways, it would, by finding that sporting facilities are negligent in these cases, it might cause those facilities to start providing helmets, requiring helmets, making these warnings, and thus preventing these accidents, which seem to be causing a certain cost to society. So here, for its determination of liability, some of the judges wanted to take into account the fact that, hey, maybe we should be deterring this type of behavior because it's costly to society. And we happen to know these statistics about accidents and the cost they have to society. So Justice McHugh was in favor of the High Court being able to take these facts, this evidence into account in its decision. And he made a pretty common distinction that exists at common law, but is not mentioned anywhere in the Evidence Act, between what's known as legislative fact and adjudicative fact. So adjudicative facts are facts that go to determining the outcome of a particular case, and legislative facts aren't really about the specific dispute as much as an appellate court's determination of what is the appropriate policy to set that lower cases would have to follow. And McHugh is right in that at common law, the rules about judicial notice are more flexible for legislative fact than they are about adjudicative fact. So, give an example. It'd be pretty clearly wrong at common law for a judge to do some research about the accuracy of DNA evidence to determine, was this DNA actually left by this criminal or the accused person, because that goes to adjudicating that specific factual dispute. Whereas a legislative fact would be more something like what's the case in Wood, or what is the case in Wood, where it's not really about determining was MSH negligent per se, but if we should make a rule that makes companies like this negligent. They are matters that are not particular to the parties. You can read that at paragraph 62 and 63. So it says it's totally legitimate for judges to take notice of these kinds of facts. Provides also a pretty useful overview of the law. Gives you some useful definitions. I won't go over these, but you can read them on your own time, and I have some what I think are the more useful passages highlighted there. Getting more specific towards the use of statistics, give some cases here. Now, as I mentioned, the problem that McHugh runs into doesn't really resolve it, is that Section 144, he's reviewing the common law, Section 144 does not draw this distinction. And however, you might recall Section 9, the Act does not affect the operation of a principle or rule of common law or equity, unless it does so expressly or by necessary intendiment. In this case, it's sort of hard to see how the old common law of judicial notice could operate under the pretty specific strictures of Section 144. And that's, we're going to see that come up in article. Justice Callanan would not allow in these legislative facts for a variety of reasons, which I'll get to, for two reasons. Would resist the fact that we should take less caution when we're dealing with legislative facts. One of the reasons being that they do also affect the instant case. And that's the first reason given here. The first reason is the parties must be given an opportunity to deal with all the matters which the court regards as material. So to let judges bring in this legislative facts without the proper procedures would offend some notions of fairness. The second reason being that we're not sure it's reliable. These are not things in which there are universal acceptance. And I think then Justice Callahan goes on to talk about, maybe I want to take judicial notice of postmodernism, which would say there is no truth, which is kind of a fun thing to say. We get, I think, a little more guidance on this in a case that you might remember when we talked about under the discretions, Article and the Queen. This was, if you recall, it was the case in which the accused challenged the notion that evidence was expressed both as a frequency ratio, which the accused liked because it kind of made more obvious the possibility of error. There's an error one in every 600 times. But the accused didn't like that it was also expressed in terms of this exclusion percentage, 99.9%, which makes it sound almost like 100%. Wanted to exclude that. Interestingly, there was no, as noted in paragraph 20 here, any evidence about whether people actually do treat those two statistics differently wasn't brought by an expert witness. It wasn't brought through the appropriate channels. Can we take judicial notice of it? Paragraph 20 here, the court says, well, this is not law. This is not a section 143 thing. This is psychology. We need a psychologist to come in here and do that. And it says, well, and also now we have section 144. Before a court can take judicial notice of such a proposition, the provisions in section 144 would have to be met. As the majority of this court noted in Catalaro, in New South Wales, there would appear to be no room for the operation of the common law doctrine of judicial notice, strictly so-called, since the enactment of the Evidence Act. It seems to pretty clearly establish that we're in a different world now than we were before the Evidence Act when it comes to judicial notice. And maybe there was some more laxity there before, but that doesn't seem to exist anymore. And at least in this case, these propositions from psychological articles aren't common knowledge. So they should really be brought by an expert witness instead. Further evidence of, I think, of this stricter approach can be found in this family law court case, Maluka and Maluka. This case has drawn a lot of attention by academics as well. You might especially be interested in the work of Zoe Rathis, who's written a lot in this area. So here the judge, in a somewhat cavalier way, referred to evidence that was not brought by the parties that the judge was aware of. I think it was a he. It was a case about the parental order that was ordered by the judge about the amount of time the father could see the child. And the judge was aware of some research on different types of family violence. partially just used that, I think, in a way that was not challenged, to just kind of, as jargon, as terminology, a classification system used to maybe simplify the order and the judgment. So part of it was just using it to categorize family violence, which was fine, but it was also pretty clear, Section 8996, that he went beyond that. What the material does do is enable categorization of the father's violent predisposition and provide the court with further evidence of the likelihood of the continuation of that violence. So using the social scientific evidence about domestic violence to also inform this judge's opinion, this judge's order, that the father's violence would continue. And that is where we run into some problems, because this was not evidence that was cross-examined and brought by the parties through the normal adversarial strictures. Also, none of the parties really wanted this. The independent children's lawyer, the ICL, the father didn't like this. The judge could use the material in aid of his own general learning in relation to which he submitted, but that is the extent of it. It was strongly argued that this was not common knowledge. And the mother didn't want this either. Now, Your Honor, my concern with respect to that is that there have been 9 days of evidence and submissions, and there is more than enough evidence for you to make your findings. We don't need to get into this social scientific evidence. But as judges do, they really wanted to use it. And the reviewing court here makes essentially the same points that Justice Callanan made in Woods. 2 main problems: it's not common knowledge, and second, there should be some sort of procedural fairness here in which the parties can vet this and make submissions about it. And, I'll leave that just for timing reasons. You can go over that yourself. Yeah, there are actually, and this is that paper I just talked about that actually just came out earlier, a few days ago, actually. But there are several ways in which knowledge, exogenous knowledge that was not brought by the parties, that is not common knowledge, can be brought into court. And I think that all of them have problems. So in this case, I cite there are several cases, some Australian, some Canadian that I cite. But one I note is, in this case, Lalonde, which says, it would be absurd and wasteful to require expert witnesses to attend the court for the purpose of describing generic battered wife syndrome. Such experts may not be available in remote and isolated communities. So instead, the court just cites a previous court's review of battered wife syndrome. So this is another sort of end around of the normal sort of adversarial processes, the use of expert witnesses. This evidence has been admitted before in a previous decision. Ostensibly, it passed all the rules, so I can read it into the record here. And I think this is a good example of the problems of that kind of thing, because generic battered wife syndrome was never a very reliable syndrome. There was never much research behind it. But so possibly problematic just to bring it in through not legal precedent, but factual precedent. So we know that previous courts' legal decisions are, in a common law system, are either quite persuasive or binding on a lower court or a court at the same level. But factual decisions aren't. But this seems to be establishing some sort of factual precedent. But there's a real cost because as this court does rightly note, experts are not always available. So how do we get this knowledge into courts through the appropriate channels? In this article, I advocate for pre-recorded expert evidence that's actually already been cross-examined by a party with the same interests as the adverse party in this case. So you have an expert come in and talk about intimate partner violence, have them cross-examined by someone who works for the Crown, and record that and play that for in any case in which it's relevant, is my idea. And also don't forget section 116, directions to the jury. We talked about this before in the context of identification evidence, but a judge is supposed to warn a jury about the dangers of identification evidence, the foundations of which are scientific. There's psychological research about the effects of various factors like timing and cross-racial bias on someone's memory. That actually, if a judge were to go a bit farther in these directions and actually explain that these instructions are based on scientific research, which is true, you could argue they're offending section 144. So there's a case again here, I think, for pre-recorded expert evidence. Finally, I'm recording this during Open Access Week. I'm sure many of us have been annoyed when we try to pull up an article, scientific article. We're not logged in to the University of Sydney website, and so we can't get access to it. This is I think a 2018 article by Zoe Rathis in the Federal Law Review, finding that many practitioners are very annoyed by the fact that they want to look up social science research about a case they're working on, but they can't get access to it. So if you ever end up writing something, make it open access. All right, final topic. Let's talk about warnings. Kind of the more general part of this, the rules regulating the warnings that the judge can give the jury about certain types of evidence, requiring certain warnings and discouraging or preventing other kinds. Take a walk through sections 164 to 165, which abolish some of the old requirements at common law, introduce new ones, and forbid some. So starting off with section 164, this abolishes the common law requirements for corroboration. So the direction to the jury that you cannot convict unless there is corroboration of this evidence. Common law, there were particular kinds. I think one common one was with jailhouse informants, a notoriously unreliable type of evidence because oftentimes the informant would have been given some sort of deal to give the evidence, to say, oh yeah, the accused confessed to me. These requirements are abolished, except for the requirements for corroboration when it comes to perjury under subsection 2 here. The justification for requiring corroboration here still, I think, is that if it's too easy to prove perjury, people will be less willing to come forward and give evidence. So there's a requirement that evidence of perjury be corroborated. So this constrains the proof process significantly for perjury, but you can see it liberalizes it for pretty much everything else. We're trusting juries to properly weigh up the evidence and understand that there are particular kinds that are perhaps weaker, or that there are to place the appropriate weight onto evidence. The kind of replacement of the corroboration requirement is a warning. It's a safeguard that maybe you could say it responds in a more flexible way, and it's not tied to corroboration per se. Here, the idea, and again, don't forget section 116, where there's a similar rule for identification evidence. It carves out, subsection 1 provides several specific types of evidence, but you can see in subsection 1 that it also applies to any kind of evidence that may be unreliable. And A through G are specific examples. And in cases like that, if there's a jury, the judge must warn the jury. Gives the specifics of that, subsection 2, the substance. However, if there are good reasons not for doing that, the judge need not do that. Subsection 4, no particular words are required. And I'll let you read the rest yourself. This went slightly more broad than the Law Reform Commission's suggestion, which only had specific types of evidence. This has that residual of a kind that may be unreliable language. What does good reasons mean? This has been interpreted by different courts to mean things like the evidence is not disputed, it's not that important to the case, or that the judge has found under other indicators of the evidence's reliability, like it being hearsay from a very reliable source or being consistent with other evidence. Now, this subsection does not clearly rule out the common law. There's nothing in here to suggest, either expressly or by necessary entendment, that the common law requirements for warning of certain types of evidence no longer exist. And some of those, you can see your text for more. Some of those include cases in which the case depends on just one witness, consciousness of guilt evidence, I should say consciousness of guilt, and cases in which the prosecution has not made the evidence available for testing by the defense's expert. If you're interested, because it is sort of kind of hard to understand how these work in the abstract, for most of these you can find sort of the standard judge's bench book direction that they'll often use to adapt to a specific case. I've put a link to one of them up. This is a 165(1)D warning. It's when the witness is someone who you might reasonably think is a criminal who was suspected of this very crime. Therefore, the worry is that they are giving evidence against the other person to deflect blame from them, or because they've been given some sort of deal. I'll just read a little bit. So this is just quoting. "My purpose in giving you these directions is only to warn you that the evidence of such a witness may be unreliable, and for that reason, you must approach the evidence with considerable caution in the way in which I will outline shortly. There are many reasons why the evidence of such a person may be unreliable. Possible reasons are, it is only natural, you may think, that a witness who was or who might have been involved in the alleged crime may want to shift blame away from themselves onto others." On and on it goes. You can read that on that link. Gives you a bit of an idea of why a party might want such a warning. Crown and Flood gives you maybe a little guidance on how to determine if evidence may be unreliable and how high that bar is. I think it means to say 165 sub 1, not 165 sub A. That test involves a low threshold as a precursor to giving the required warning, more is required than some general argument that the evidence may be unreliable. Some reasonable basis must appear. And you can read on from there. Now note here that all of the required warnings are not in the Evidence Act. As you know, that's often the case. Some other ones that I'd like you to be aware of are in the Criminal Procedures Act, sections 293 to 294AA. These are typically in sexual offenses cases. So just by way of example, before I get into some more specifics, 294 AA is a warning, forbids the warning that that might suggest that complainants in sexual assault cases are unreliable witnesses. This, you might see, responds to maybe some antiquated notions about people who make allegations of sexual assault. 294A, this applies to when there is, just 294. This applies when there's a suggestion that the complainant's lack of immediate complaint means that it's not a genuine claim. This is the result of reforms that respond, to the common attack on a complainant's credibility that, oh, if you didn't report this right away, it means that it was fabricated. And I think it's pretty well known now. I think some of those might just be based on these old ways of thinking, probably based on stereotypes, myths, and some sort of ingrained sexism. But I think I think we can understand now that there are a lot of reasons why somebody might not make an immediate report: societal expectations, fear of reprisal, embarrassment, several others. So subsection A here, this section applies if there's some suggestion, typically by the defense, that there was some sort of delay in reporting, and that delay is meaningful as to whether this actually happened. And then subsection 2, the judge must warn that absence of complaint or delay does not necessarily indicate that the offense committed, that the allegation was false. Now there was, after this, some lack of clarity about whether 294, by necessary implication, had the effect of forbidding that a warning be given, that because there is a delay, you might want to lower your judgment of credibility here. You might want to think this allegation was false. For instance, if there was a very long warning, there was a very long delay, or some other circumstances were into account, could a judge still actually make a warning going the other way of 294 and say, you might take into account the fact that because there was such a long delay, perhaps it's not a genuine claim. That was at issue in Crofts. So it was a somewhat long delay, and the trial judge gives the 294 warning and refuses to give the Kilby warning. The Kilby warning is that warning that because it was such a long delay, you might not believe the complainant. Says, well, I can't give that anymore now that we have 294. And the accused says, well, in some cases, you might have to balance out that 294 warning and say, however, you can take into account that delay if you think it's appropriate on these facts. So the issue is Kilby still available? When is it appropriate? And the court here finds in favor of the defense. on the particular circumstances in the case. The delay may be so long, so inexplicable, so unexplained that the jury could properly take into account that the allegation was false. On these facts, it was quite a long delay. And finally, that last passage suggests that the purpose of, so this case was not actually considering 294 because it was heard in Victoria, but it was considering the analogous provision there. The court here says, the High Court says here at in the last section, is that it wasn't the intention of the legislature to say that it was there to balance out previous stereotypes, previous practices, but it wasn't there to make all complainants automatically have maximal credibility. It was there to balance out the previous practices. Final two, 165A, 165B. 165A came into effect after agitation, similar to that we talked about with the tenancy evidence reforms. This was the concern with prosecuting child sexual offenses. That judges were being too liberal in saying that jurors, you can take into account the fact that kids often have poor memories, misunderstand some things, misremember things. And this actually forbids such a blanket warning. Subsection 2 provides some limits on that. So you can't say that kids are, subsection 1, you can't say that kids as a class are unreliable, but this doesn't stop you from suggesting that, it doesn't stop a judge from warning on a particular case, on particular facts, that a particular child may be unreliable. Finally, for this bit here, 165B, delay in prosecution. This is responded to and essentially is a part of the common law longman warning, which you may have heard about, which judges would typically give in cases of a historic sexual assault case. So something that happened many, many years ago, 20 years ago, 30 years ago, shorter than that sometimes, saying that, sure, you should take into account the fact that it's very difficult to defend yourself in some of these cases because lots of the evidence, like of an alibi that you might have had, is now lost to time. So you could take into account that the accused is at a forensic disadvantage here, disadvantage in proving their case. $165B seems to have, it encapsulates that warning, but it seems to narrow longman in some way by saying that there has to be a significant forensic disadvantage. That wasn't really the case at common law, and there was a perception that prior to this provision, judges were giving longman warnings even when they were just a very minor forensic disadvantage. So they were being given that too liberally, and this seeks to sort of constrain that. All right, a final two external perspectives on proof. So we've talked about these ways, by providing a warning, direction, by bringing in exogenous evidence, that judges can press their thumb on the scale. But let's talk a little bit more about that from a slightly different perspective. I think one useful thing to think about is, has there been any research on how useful these instructions, these judicial comments actually are? Because given all this legislation, given all this law reform, all these cases, it seems like the assumption is that they work very well. But do they actually? So the first thing to note is that the research that is available suggests that they don't work that well. They don't change decisions very much. They aren't very well understood. They aren't very well remembered. But to that, I would add a caution that the majority of these studies that have been done on mock jurors have used kind of more general instructions. And by that I mean instructions about, here are the elements of the offense, here's what must be proved, here is the elements of the defense, so here's the offense, the defense, here are the factors. If this happens, if the prosecution raises this, then defense must raise this, and if you're convinced of X, Y, and Z, then you must determine this. That sort of chain of reasoning type logic. There hasn't been as much research on just general warnings about certain types of evidence. But what does exist also tends to find that they aren't very effective. So I think it's interesting to note that there are so much argument about something that we don't even really know that it works very well. One of the articles I asked you to look at is this meta-analysis by Chantal Begley and colleagues at UQ. What they did was they looked at a lot of previous studies and said, okay, based on these previous studies of new tweaks to instructions, what seems to be working the best? So in light of the demonstrable lack of effectiveness of instructions, lots of psychologists have been doing lots of studies trying to improve them. Things like providing a factual example along with the instruction to make it more concrete, or providing a written copy of the instructions, or providing sort of like a logical sort of flow chart about how to reason through the evidence. And this meta-analysis actually kind of challenged some previous views. So it found that the linguistic complexity of the instruction didn't really matter. So we kind of thought that using simpler language, lack of jargon would help. That didn't really seem to matter. It was the conceptual complexity. So the more legal concepts that were in an instruction decreased its effectiveness, and it also found strong support for the use of those decision aids, those flowcharts. So going forward, those seem to be fertile areas of ways to reform instructions to make them more understandable and fulfill what judges already think they do, which is affect the reasoning of jurors. Final perspective I want to bring in comes from this Mark Spotswood article on continuous burdens. So what he notes, so this harkens back to what I talked about at the very beginning of this lecture, and what David talked about earlier, class 1. We have these burdens of proof, the most fundamental aspect of proof. What threshold do you have to meet? And they are, as Spotswood calls them, discontinuous. They're either you meet it or you don't. So either you convince the jury beyond a reasonable doubt, convince the fact finder beyond a reasonable doubt, or you don't, or you either convince the judge or you don't on the balance of probabilities. So it would work like this. 50% here in the middle. This is the degree of the fact finder's belief at the bottom. And the y-axis is the damages, so that this is a simple case. So anything up into 50%, the plaintiff gets nothing. And then as soon as they convince them just above 50%, they get everything. So you can see the criticisms of this. It's somewhat crude. If a judge is 51% convinced, just slightly over, they get everything. They get the same as if they were 99% convinced. So there's no added benefit of further convincing. Conversely, we give a completely different judgment to something that is 49 and 51, even though the degree of certainty there is almost the same. So it's just not very sensitive to the facts of the case. Spotswood also notes there might be some under-deterrence here. So corporations, pretty sophisticated, they might know that they can behave negligently up to a certain point that it's provable. So they're going to always, they are motivated to save money, do a little bit of negligence up until the point they think they can get caught. And unless they create enough evidence, convincing evidence to find that they're liable, they pay zero. There's zero ramifications. You can make a similar case for employment cases, so long as there are plausible other reasons for firing someone other than the illegal one. It's hard to prove the case on a balance of probabilities, so employers might be more willing to do that. You might recall Gama's case. And finally, if you were in any of my tutorials for the first couple of weeks, we talked a little bit about that blue bus problem in evidence law. That's the situation in which somebody's hit by a bus. There's no evidence of which bus it was, but we know that along this route, 70% of the buses are from a certain company, the blue bus company. So just statistically, you should say they should be completely liable. And that seems to offend some people's notions of fairness. Like, why should this company pay all of the damages when all they really did do wrong for sure is be the dominant player in the market? And maybe we would find it more fair to only make them 70% liable in cases like this. So what Spotswood proposes is a continuous burden of proof. So if the fact finder is convinced 40%, you pay 40% of the damages. And there are multiple reasons why this might make sense. As I already noted, it might have better deterrence power. So company that's being a little bit bad has to pay, still has to pay. Might be fair, as I just mentioned, to find liability in a less all or nothing way. And finally, another reason mentioned by Spotswood is that the all or nothing approach can allow small, inconsequential things to sway a decision. And it can be the sole reason. So if you're just at 49% convinced, a little bit of a facts that are just a little bit more emotional, a little more sympathy provoking might be enough to shift you over the edge, which kind of seems unfair that such a small factor could have such a large effect, but that would never be the case with a linear burden, a continuous burden. So lots of reasons why this would never happen, but I think it's something interesting to think about. So that's about it for me. We've talked, just by way of recap, we've talked about when can the judge make a comment about the fact that the accused did not give evidence, seems after, as a party, limited situations in which the accused would be the only person who would have information about something, and they really should have that information. Kind of like a case in which they were in a boat with somebody and they must have seen something happen. Talked about the limits largely under Section 144 for judges to bring in exogenous non-common knowledge into the courtroom. And we talked about the abolishment of the corroboration requirement for most cases and the requirement for warnings in some cases, and abolishment of some sort of old warnings that were probably based on misguided views of human nature. Thanks very much.